This is actually a webinar co-organized by Manja and myself, so I think I will be in a proper role to do the introduction as well. Can everyone hear me? Good. Okay. Now, you've got the poster. Actually, we have a very stellar team of panelists today. We have Professor Dr. Prasad Abraham from Asian International Arbitration Center, located in Kuala Lumpur, Malaysia, who is representing from the arbitration institution sector. We also have Professor Man Zhaochi, our moderator today, also my successor, and then the current co-chair of the American side of the International Asia Pacific Interest Group, who is the leading investment law expert in China, as well as in the Asia Pacific. We also have Ms. Susan Finger, the distinguished scholar in residence at the Peking University School of Transnational Law, based in both Shenzhen and Hong Kong as well. And then Susan has very close relationship with Hong Kong U as well. So thank you for joining us, Susan. And myself, and then Professor Yukun. Oh, Manja, you want to jump in? So that will flow over to you. Manja, are you able to talk? Oh, Manja is back. So we've introduced to Professor Yukun Nishtani. Maybe I will hand over to you so that you can continue with Professor Yukun Nishtani.
Sorry, I'm sorry. I don't know what happened, because it seems to me that everything is normal, but then I heard you were saying you can't hear me, can't see me. So I'm sorry for that. Okay, Wisha, I'm sorry, I lost your words. Would you please just go ahead with the introduction, then I will do the moderate.
Sure.
Thank you.
Then, well, my pleasure. Professor Yukun Nishtani, my very good friend, the leading expert of private international in Japan, a very distinguished professor at Kyoto University, not Tokyo, but Kyoto University, and also among the curatorium at the Hague Academy of International Law, who is the leading powerhouse of both public and private international law throughout the globe. Last but certainly not the least, we have a very eminent practitioner and in the Asia Pacific region, Mr. Challen Sun Etsy, Senior Counsel from Duxton Hugh Chambers in Singapore, who is also the leading suit, not only in arbitration, but also in all the types of international dispute resolution. So with that, I would turn over back to Manja for moderating. Thank you.
Thank you, Wisha, and again, apology to all our audience. I'm sorry for this technical difficulty. So I should just follow what Wisha has said. To moderate today's webinar, we have a very interesting topic of charting the new frontiers of international dispute resolution in the Asia Pacific. And we all know that especially in this region, a lot of things has just happened in the past few years. For example, we have the Singapore Mediation Convention, and then we have quite a few international commercial courts established and functioning in this area. So today we're going to charting the new frontiers of this international dispute resolution. So we have, as Wisha has said, we have 5 distinguished speakers today. I would not repeat what Wisha has said. They are all very distinguished and knowledgeable in this field. So without further ado, let me first of all invite Professor Wisha Gu to cover the general international dispute resolution and private international development in this region in the past few years. So Wisha, the floor is yours.
Thank you very much, Manja. It's my great honor and pleasure to be back to AIAC. I feel like going back home. Since we launched this webinar and then we designed a poster about half a year ago, I started to reach out to various of you among the panelists today, and then we are very glad that we are able to make it tonight. I've prepared some visuals, and let me share my slides. So everyone can see my screen? Sure. Okay. So as I have prepared, let me show you before. Now you will see that this is a visual chart about. Firstly, let me deal with and then provide a sketch about basic background of the international arbitration market in Asia. In 2017-2018, Justice Samuel Reyes at the Singapore International Commercial Court and myself, we co-published a book called The Developing Mode of Arbitration in the Asia Pacific. In particular, we identified there's a very vibrant, rigorous institutional arbitration market in Asia, where Mr. Chalan Sanatsi also very kindly accepted our invitation to contribute in the Singaporean chapter. Now you will see that in this very vigorous Asian or Easternized arbitration market, you will see that most of the jurisdictions, if not all, they have established arbitration institutions to compete in this market. So you will see on the right hand of the PowerPoint slide, you will see those of the leading names in Asia, including CTAC, headquartered in Beijing, but with different branches throughout China. You have JCA in Japan, KCAB in South Korea, HKIC in Hong Kong, VIAC in Vietnam, SIAC in Singapore, Bali in Indonesia, AIAC in Malaysia, and Thailand. According to the latest figures, you will see, according to the caseload statistics, CTAC is the best in terms of caseload record, 2,298. So this caseload figures even more than the calculation of ICC plus LCIA in the past 1 year, or in the past 2 years, I would say. The second would be SIAC, and then Singapore is doing very, very well, I would say, not only in terms of the number of the cases they have been handling in the past 1 year, but also in terms of the disputed amount. They have been holding the champion throughout the Asia Pacific. And then in terms of the background of the disputants, they are also the most international among the Asia Pacific. And you will see that KCAB in Korea is doing very aggressively in the past few years. Of course, HKIC, in the place where I am teaching in Hong Kong, is also doing extremely well. So this is about a picture, and then how do they compete cases? How, in terms of the the caseload composition that have been developed in the past few years. You will see that in this very interesting arbitration market competition, the leading arbitration institutions like those in Singapore and Hong Kong and Beijing, also in South Korea and Malaysia, they have been keep on updating their arbitration rules to formulate attractive rules and to adjust their fee structures to provide best practices to their consumers. There are also very sound and solid judicial support to arbitration in respective jurisdictions. Now, the second slide is about litigation. Well, as we've seen that, there are three major pillars in international dispute resolution: litigation, arbitration, mediation. So in addition to arbitration, you have a lot of international and cross-border litigation taking place in the Asia Pacific on a day-to-day basis. So international or cross-border litigation, they can be heard by both local courts as well as international commercial courts. And the international commercial courts, they are new species in the international dispute resolution institutions in the past decade in the Asia Pacific. You will see that I have listed three most sort of, those ICCs in Asia, in the Asia Pacific, which have been taken shape in the past 5 years. I didn't list Dubai because Dubai is slightly earlier, it's in 2005. So I have listed SICC, established in 2015, the Astana International Financial Center called AIFC called in 2017, and the China International Commercial Court, which most recently took shape in 2018, June. And on the right-hand side, which I know that my very knowledgeable co-panelist, Professor Yuki Nishitani, would unveil her insights about the Hague Choice of Court Convention, which she herself is the insider and formulation of this convention. But just to give you a snapshot about the membership and the mobility, the chances of mobility of the judgments delivered by those international commercial courts, you will see that Singapore is doing pretty well, extremely well. Singapore joined the Hague Choice of Court Convention in 2016, and then that convention has already taken place in Singapore, which means that the judgments delivered by the SICC is quite mobile. It's actually having a lot of access to those other member states of the Hague Convention, notably EU. Because EU is a member, a regional member party to the Hague Choice of Court Convention. Astana International Financial Court has not joined. I mean, Kazakhstan has not joined the Hague Convention. China is a very interesting case study. The Chinese government did join the Hague Convention in 2017. but that international has not been ratified at the domestic level. So at the Hague Convention, the Choice of Court Convention did not really take effect in China so far. I have a forthcoming paper which I would like to share with the panelists when the conference is over. I will have a forthcoming piece in the Chicago Journal of International the typology of the International Commercial Court. And then it's pretty much a social science-driven research on the global rise of the ICCs. Now, moving to mediation, and I'll just give you a very quick outlook about how international mediation is quickly developing in the Asia Pacific, noting that my knowledgeable panelist, Mr. Talans Alexei, will pick up the topic in his subsequent talk. So Singapore Mediation Convention is also a very new international law in the private international arena, which was concluded in 2019. This convention gives cross-border effect and mediation settlement agreements, which is very parallel to the New York Convention as the parallel instrument. So you have the New York Convention on the global movement of the international arbitral awards. You have mediation, Singapore Mediation Convention given effect or given an international passport to the mediation settlement agreements. And you also have the Hague Convention, Hague Judgments Project given effect to the international judgments. In this respect, you will see that Singapore, among the Asia Pacific regions, they have ratified, not only acceded to, but also ratified the Singapore Convention and passed the domestic law, giving effect to this international in the domestic level as well in 2020. There are some other leading Asia Pacific jurisdictions which have signed the Singapore International Convention, including China, including Hong Kong as a special administrative region of the PRC, India, Kazakhstan, Brunei, Laos, Malaysia, Philippines, Korea, and Sri Lanka. But none of these jurisdictions, they have, finalized their domestic level ratification process. So you'll see that Singapore is really the predecessor in this field. Now, given our interest of time, I would just use my final slide to conclude a very interesting and new trend called multi-tier dispute resolution. You will have a forthcoming book on the right-hand side of the slide, which is also our second co-edited book between me and Justice Marcel Maurice. We find it quite interesting because we are inspired by the CICC, the China International Commercial Court's one-stop multi-tier dispute resolution platform in 2018. But backwards, we have been further, and then we find it quite interested in the Singapore International Arbitration Center and Singapore International Mediation Center, the ARP-MED protocol launched by the Singapore government in 2014. Inferring that Singapore government is very top-down driven in providing a one-stop shop of all the multi-tier and hybrid dispute resolution services, one-stop services to the consumers. And then they have been leading this trend for providing agglomeration trinity of dispute resolution services in the Asia Pacific, where China is following the suit. And then I think it's quite a trend that other jurisdictions will be following the suit as well. Okay, I will stop here, and then I'm happy that the floor is over, and then going back to my job to hear subsequent excellent presentations. Thank you very much.
Thank you, Wisha. Very insightful and informative lecture, I would say. Provides a very helpful picture for the dispute resolution landscape in the Asian Pacific region. So I believe that would be most helpful to all of us. So the next speaker will be Professor Yuko Nishitani from Kyoto University and the Hague Academy of International Law. So Yuko will cover the 2015 and 2019 Hague Judgment Conventions from the insider perspective, as well as its impact on commercial judgment and mobility in this region. So Yuko, the floor is yours.
Thank you very much for this kind introduction. Let me share my slides. Can you see my slides? I hope this.
Yes.
Okay, so thank you very much. It's a great pleasure to take part in this panel. I sincerely thank all the colleagues, Manjao and Weishia, for this great opportunity and warm invitation. So globalization is progressing along with regionalization. A rapid increase of cross-border transactions requires effective dispute resolution methods. Arbitration and mediation are often used, as Weisha explained before, and they are supported by the New York Convention and Singapore Conventions, respectively. However, litigation before state courts has not lost its importance either. For cross-border litigation, international adjudicative jurisdiction and the recognition and enforcement of foreign judgments are crucial. In the Asia Pacific, however, there is no guarantee of judgments circulation so far. We do not have an efficient system comparable to the Brussels and Lugano system in Europe. So the judgments recognition is often hampered by the reciprocity requirement. Mainland China, remarkably, has 33 bilateral treaties for judgments recognition. In their absence, mainland China recognizes foreign judgments when the foreign state has already recognized a Chinese judgment in the past. So based on the factual reciprocity, Germany, Singapore, the US, and South Korea have been able to establish a recognition relationship with mainland China. However, so far, Chinese courts and Japanese courts have unfortunately said mutually that there is no reciprocity with the other state. That means that Japan and mainland China are very important trading partners, but there is no judgment recognition between mainland China and Japan currently. The situation is similar with Indonesia and Thailand, which require reciprocity by treaty. And some other Asian countries like the Philippines, Vietnam, Cambodia, and Myanmar also take a restrictive approach towards recognition of foreign judgments. So from this perspective, it is important to bridge among Asian countries to ensure judgment circulation within the Asia Pacific, and also try to bridge between the Asia Pacific and other regions such as Europe and the United States and other parts of the world. In order to do that, joining the Hague Convention would be a viable and important possibility. So from this perspective, I'd like to address and analyze the 2005 Hague Choice of Court Convention and 2019 Hague Judgments Convention. The 2005 Choice of Court Convention on exclusive choice of court agreements is a double convention. So this convention regulates both direct jurisdiction and the judgment's recognition. This convention aims to enhance certainty parallel to the 1958 New York Convention. Its scope is limited to commercial disputes. And it excludes also several issues where it's difficult to reach agreement when negotiating the treaty. The 2005 Convention has 3 pillars. Among contracting states, first, the court of state A, which was chosen by the parties, is obliged to hear the case in principle. Second, the court of a different state B, which was not chosen by the parties, has been seized by one of the parties afterwards, then the court of state B has to decline to hear the case, unless the choice of court agreement is null and void or public policy is involved. And third, when the court of state A, which has been chosen by the parties, renders a judgment, all the other contracting states ought to recognize and enforce that judgment. That's the structure of the 2005 Convention. The 2019 Judgments Convention is a single convention. So it only deals with the judgment's recognition. It aims to enhance access to justice, and it complements the 2005 Convention, but there are also some deviations in the 2019 Convention. The 2019 Convention does not apply to certain sensitive issues like defamation and privacy or intellectual property, so they are excluded from the scope of the convention. However, the 2019 convention does cover immovable property and tenancy, as well as consumer and employee contracts, unlike the 2005 convention. To facilitate the judgment circulation, the 2019 convention opens for contracting states other avenues of recognizing foreign judgments by domestic law or other conventions. So this means that the states are free to decide whether to recognize a foreign judgment under the 2019 convention or under domestic law or other conventions. The only restriction provided by the 2019 convention is that contracting states are bound by the exclusive jurisdiction of the situs of immovable property as to its rights in rem dispute. The 2019 Judgments Convention serves to enhance legal certainty by limiting the indirect jurisdiction grounds to reasonable ones and also clarifying the grounds for refusal. So what will be the impact of the Hague Conventions? The 2005 Hague Choice of Court Convention has so far attracted 32 contracting states. They include the EU and its member states, Denmark, the UK, Montenegro, Mexico, and Singapore in the region. States that have signed the 2005 convention include the US, Ukraine, North Macedonia, Israel, and China in the region. So their ratification is anxiously awaited currently. The 2019 convention has not yet gained contracting state, but 3 signatories. They are Uruguay, Ukraine, and Israel. However, following a proposal of the European Commission this month, the European Union will presumably soon become party to the 2019 Judgments Convention. As authors discuss, the UK will also enormously benefit from the 2019 convention when it joins it, as the UK is no longer a part of the Brussels and Lugano system after Brexit. When we should analyze the significance of these instruments, we can say that both the 2005 and 2019 Hague Convention serve to enhance legal certainty and ensure access to justice. They will also reduce risk and costs by ensuring swift judgments recognition. Litigation itself has also advantages. It ensures transparency and fair trial by independent judges. Litigation is far less expensive than arbitration and is friendly for small and medium businesses. The fact that the judge can also order binding interim measures is also an advantage. In addition, as Weisha has addressed already, the 2005 convention allows parties to refer to a specialized court of their choice. So in the Asia Pacific, the Singapore International Commercial Court and the Chinese International Commercial Court play an important role. And as Weisha mentioned, the Kazakhstan Astana International Financial Center Court is also catching up with the other international courts. And there are some other international commercial courts, like in London and Paris. So by having this kind of framework to ensure that choice of court agreement of the parties is given effect and the judgment's recognition is ensured resulting from the court chosen by the parties, this will enhance legal certainty and probably it allows also a positive competition of venues for dispute resolution in the future. In the Asia Pacific, Singapore, Hong Kong, and Shanghai, and hopefully also Tokyo will be able to compete with other advanced venues for dispute resolution. Notably, so far, concern has been expressed as to states that may not have independent judiciaries. So what we should do with these kind of states? The Hague Conventions, however, provide sufficient tools to circumvent this kind of problems in my eyes. Under the 2005 Convention, parties can avoid problematic venues by choosing an appropriate court of different states. Furthermore, the 2019 Convention provides for, in its Article 29, the so-called bilateralization. This means that contracting states are allowed to decide whether they want to establish a treaty relationship with certain states. So if they do not want to establish this kind of treaty relationship, then they can opt out and say that they do not want to have a treaty relation with that state. So by this kind of safeguards, I think we can circumvent the problems of states that may not have independent judiciaries yet. The 2005 and 2019 conventions also live up to public policy considerations. They exclude sensitive matters from their scope. And the 2019 convention also excludes controversial jurisdiction grounds. So they rather limited the jurisdiction grounds to appropriate range so that states can agree and join the 2019 convention without difficulties. The 2005 convention also allows states to retain the case once the court has been seized if an important interest of that state is at stake. So even though a different court has been chosen by the parties, the seized court can say, we retain the case and render a decision ourselves when an important interest is involved. And ultimately, both the 2005 and 2019 conventions allow refusing the judgment's recognition on grounds of public policy. So again, we have sufficient safeguards to refuse recognition of judgments when recognizing them would run counter to public policy of the recognizing state. As a result, the 2005 and 2019 Hague Conventions provide realistic solutions and are advantageous in enhancing access to justice and the judgment circulation in the region. The reciprocity requirement, which has hampered the judgment's recognition between mainland China and Japan, and also with other states in Asia, will be overcome when states start joining these instruments. So it is hoped that judicial cooperation and economic developments in the Asia-Pacific be enhanced with these instruments, and possibly also with the envisioned new Hague project on direct jurisdiction. Thank you very much for your attention.
Thank you. Thank you, Yuko. This is a very informative, very systematic discussion of the two important conventions. Thank you. So our next speaker will be Mr. Chaman Sang, SC from Duxton Hill Chambers of Singapore. He is a very renowned law practitioner in the field of commercial law in the Asian Pacific region. And he is going to discuss the 2018 Singapore Mediation Convention. So the floor is yours, Chaman.
Thank you very much, Manjiao. Very pleased to meet you online, all of you, and thank you for joining us. Mediation, as I think nearly everybody knows, is a completely different animal from arbitration or litigation. There is no adjudication or determination of the dispute in mediation. The mediator is just a facilitator. But if parties settle, and it's really up to them whether they want to settle or not, what you have is a settlement agreement. In other words, you end up with another contract. But this time, the contract is hopefully more simple and clearer and more easily enforced. Unlike an arbitration award, which has the benefit of the New York Convention, making it enforceable in 168 countries, until recently, there was no international instrument that obliges a state to recognize and enforce a settlement agreement based on contract. and be faced with all the defenses that can be typically be raised against a contractual claim. You have already heard just now from my colleagues about this Singapore Mediation Convention. The work on this United Nations Convention on International Settlement Agreements arising from mediation is quite a mouthful. So for short, it's called Singapore Mediation Convention. Started in 2015 and was completed within 2.5 years. That's very fast by UN standards on completion of a treaty. And I think that goes to show how much generally countries like the idea of enforcing agreements arising from mediation and promoting mediation. The Singapore Mediation Convention received overwhelming support when 46 states turned up to sign it at its official signing ceremony in Singapore. The Singapore Mediation Convention came into force on 12 September 2020. As of now, 54 countries have signed it. 6 countries, including Singapore, has ratified it. The convention applies to international settlement agreements resulting from mediation, which are concluded in writing to resolve a commercial dispute. A contracting state is obliged to enforce a settlement agreement, and enforcement may be refused only on specified grounds, such as the settlement agreement being null and void, if the obligations in the settlement agreement are not clear or comprehensible, or if there was a serious breach by the mediator of standards applicable to the mediator or the mediation. I will not go into all the technical elements of the convention. Maybe it suffices to note here, for example, that the ground that for refusing enforcement of a settlement agreement based on a serious breach of standards by the mediator is an interesting one, because as of now, there's hardly any work on what are the common standards that one can expect in a mediation. At least with regard to arbitration, I think it's pretty well established that an arbitrator has to be impartial, has to act with neutrality, there must be due process, give each party an opportunity to be heard, and all kinds of things that an adjudicator has to pay attention to. But a mediator's role is slightly different. An example of this kind of issues came up in a well-publicized case, which was an award rendered by the CN Arbitration Commission. The case is Haiyan against Kenai. I think Manjiao and Wei Xia would know about this case. In that case, which was an arbitration in China, a third party friendly to one of the parties concerned had arranged with the CN Arbitration Commission to host a feast, and which was attended by one of the party's nominated arbitrator to discuss settlement. And later they went to the presiding arbitrator's house to continue to discuss the case. So, well, it wasn't settled and there was an arbitration award, and the other party then complained that there has been a breach of the neutrality of the arbitrator. But the thing is, in China, it's quite common for an arbitrator to act as mediator. The CN court upheld the award and said that, well, it's permissible for the tribunal to chair a mediation and to invite other people to help. That's part of the culture. When the award was being enforced in Hong Kong, it was actually upheld by the Hong Kong Court of Appeal, which says that, well, whatever concern you might have about this kind of mediation, if this was conducted in Hong Kong. But the thing is, it was not conducted in Hong Kong, so you have to pay due regard to the culture and understanding of how mediation is normally conducted in the place where it took place. And therefore, they rejected the challenge and allowed enforcement of the award. But this brings to mind the question within the Singapore Mediation Convention, right? What are the standards of mediation? And I think that this is an area where eventually more lawyers, more countries, more mediators need to come together to come up with a common set of standards so that people are comfortable and you don't have different degrees of application. There is a sister instrument to the Singapore Mediation Convention, is the Ancestral Model Law on International Commercial Mediation and International Settlement Agreements resulting from mediation, 2018. And this is to give countries a sample, a template, if they do want to, if they do want to draft their own mediation laws that can be used as a model law. I now move on to the trend regarding the use of mediation, hopefully cover in just a very few quick minutes. There has been a trend towards using arbitration together with other forms of ADR, as opposed to arbitration on its own. In the Queen Mary University of London 2021 International Arbitration Survey, 59% of the respondents preferred arbitration in conjunction with ADR, for example, mediation. In Singapore, there are two mediation centers. One is the Singapore Mediation Center, which is the older one. The newer one with a focus on international mediation is Singapore International Mediation Center, SIMC, which was launched in 2014. It was off to a slow start as any dispute center, but there's a constant upward trend. The caseload in the first 6 months of 2021 is double that of the same period in 2020. The total cases to date are more than 170, and the value in dispute is more than US $4.4 billion, with an average settlement rate of 70 to 80%. One of the protocols that parties can actually use as a combined or hybrid form of dispute resolution will be something like the SIAC, SIMC, ARP protocol. It's a collaboration between the Singapore International Arbitration Center and the Singapore International Mediation Center. What it does is that if parties agree to the protocol, then they can commence the arbitration first, and it can be suspended if either party wants mediation before SIMC. The arbitrator and the mediator will be different persons. The arbitrator will suspend the arbitration, it goes to mediation, and parties have 8 weeks to conclude the mediation. If it is successful, the parties may then request the tribunal, the arbitral tribunal, to record the settlement in the form of a consent award. If it doesn't settle within 8 weeks, then you just go back to the arbitration to resume the arbitration. This model has actually been brought to other countries. SIMC, in fact, has another protocol with Japan International Mediation Center, JIMC. So this is the JIMC-SIMC joint COVID-19 protocol, specially devised during COVID for expedited mediation online. And it actually successfully completed its first mediation online under this protocol recently. The arbitration, which was a complex high-value dispute between an Indian party and a Japanese party, went to arbitration. It was stayed in March 2021. Mediation was conducted online in late April 2021, and by the second day, the parties had agreed in principle to settle the dispute. So it's a very good success story that mediation can even be successful even if done online, when normally we feel that we have to be in person to provide some kind of a persuasive element. So in brief, I think I will stop here. Safe to say that there is a lot more collaboration being built now around mediation with different international mediation centers, different entities in different countries. And I think just having more choices means it's a better service to the clients. Thank you.
Thank you very much, Chanlam. Thanks very much for your speech. You not only touched upon the Singapore Mediation Convention, but also more importantly, how mediation can be used together with other sort of dispute resolution alternatives like arbitration, and what are the challenges? Thank you very much for these insightful talk. So our next speaker would be Datuk Professor Prasad Abraham. But a few hours ago, I received an email from Datuk, and he is not able to join us today for some urgency. But luckily, we have Counsel for Asian International Arbitration Center, Dr. Anran Jiang, to join us. Dr. Anran Jiang got his PhD from Erasmus Rotterdam University in International Dispute Resolution. So he will cover international arbitration developments from institutional market vantage point with a particular focus on Southeast Asian region. So Anran, the floor is yours.
Thank you, Professor Chu. You can hear, I'm audible? Okay, thank you, everyone. My name is Zhang Ran. I'm from Asian International Arbitration Center, AIAC. I'm an international case counsel here. And we are sorry that the Deputy Director of the AIAC, Datuk Prasad, is unable to join us today. And he would like to thank American Society of International Law, Asian Pacific Interest Group, especially Professor Chu, for organizing such an amazing event. And on behalf of Datuk and the AIAC, I will present and share our views about international arbitration developments from an institutional perspective. And to start with, the AIAC as a non-for-profit and non-governmental international arbitral institution was established under the Asian African Legal Consultative Organization. And AIAC aspires to be a provider of world-class institutional support as a neutral and independent venue for the conduct of domestic and international arbitration, as well as other alternative dispute resolution ADR proceedings. So the theme of the webinar today focuses on the Asian perspectives of dispute resolution. So I will share some of our thoughts in two parts. And in the first part, we would like to highlight that Asia is an emerging economy with competitive markets. Asia is the world's fastest growing market region, contributing more than 2/3 to global growth. However, we have also to be practical to see Asia. This continent contains some of the world's most economically developed countries, but also many less developing countries. So Asia has both internal and external downside risk. For example, as until now, Asia is still facing the COVID waves. So therefore, what I would like to emphasize here is that to chart the frontiers of the international dispute resolution, we also need to consider the economical factors of the particular region and apply the ADR according to the indication arising from that region. So from a general point of view, Asia has made an active engagement in the global business and international legal order. A huge number of international investment agreements and free trade agreements exist nowadays involving Asian countries, especially ASEAN countries, China, Japan, and South Korea. And one of the milestone treaties is the Regional Comprehensive Economic Partnership, the RCEP, signed last year, which will open the Asian markets much wider. And in addition to that, several Asian countries released their master plans, which will bring continuous business opportunities. So, for example, China is transferring its entire Haiyan island to a free trade port, and Indonesia is moving its national capital from Jakarta to Borneo. And these master plans will stimulate the regional economy and attract global investment, and of course, promote arbitration business as well. So in the second part, we move forward to give the Asian solutions to international dispute settlement based on our experience. And in the AIAC, we have administered roughly 5,000 cases on arbitration, adjudication, mediation, and domain name disputes. So the AIAC can commence arbitration proceedings under the AIAC arbitration rules, fast track rules, as well as arbitration rules, which is suitable for the arbitration of disputes arising from commercial transaction premised on Islamic principles. We also offer facilities for sports arbitration and investment arbitration hearing administered by the AIAC and PCA. And we are also able to administer investment disputes under Article 33, Section 1E of 2009 ASEAN Investment Agreement. And with regard to the case management, we believe that nowadays it is important for institutions to handle international disputes and achieve international influence. Here we present some latest AIAC arbitration cases that involve international parties, international arbitrators and experts, as well as cases having significant impact in the global market. So when we operate the arbitration cases, I think when we operate the arbitration cases, we must ensure that the arbitration proceedings shall be conducted in a cost and time efficient manner. We have some figures here that the average time for completion of domestic arbitration is 27 months, and international arbitration is around 13 months. And the total cost for arbitration includes the AIAC administration fees and cost for tribunal, which may vary depending on a sole arbitrator appointed or three-member tribunals appointed. And being both time and cost efficiency is especially important and helpful to many small and medium enterprises in Asia, especially nowadays during the COVID. So according to the Global Arbitration Review Survey, we are the most affordable facility amongst the arbitration institutions worldwide. Moreover, we also put a lot of effort on the capacity building by regularly holding conferences, talks, trainings, workshops, and nowadays webinars to promote ADR in the region. And the coming big event we will have is the Asia ADR Week in August, where we will provide Asian solutions to the global market. And we also have many cross-institutional events, such as with China and with the Middle East. And we work closely with our partner institutions in the ADR community worldwide. And the notable partnership is the Asian Domain Name Dispute Resolution, jointly established with CTAD in Beijing and HKAC in Hong Kong. In addition to that, I would like to further mention two factors that we are currently working on to promote ADR. So the first one is diversity. We just had our second Diversity in Arbitration Week 3 weeks ago when we are promoting diversity to close the gap in the arbitration community, and in particular to ensure the gender diversity and race diversity. I would say Asia is a diversified region, and Malaysia is quite a good example for that. Here we have Malay, Chinese, and Indian. So when we are resolving disputes, we must ensure to protect all the interests from different parties and respect their business tradition, especially those from minority groups. In international arbitration, we should increase the voices and promote the rights to speak from Asian institutions, arbitrators, scholars, and students as well. So therefore, we are also active in encouraging the young generation, which in our mind is the future of the ADR, to play a proactive role. The AIAC has its Young Practitioners Group, the YPG, and launched the roadshows around universities in Malaysia and across Asia. We also organize raise pre-moot and draft moot problems for our Asian moot competition and support many students in events such as trainings, internships, lectures, and many other international and domestic students events. So our latest experience, as I said, can be found in the Arbitration Rule 2021, which will be officially released this Sunday on 1st of August. And it will also be used in the next Wismut arbitration competition. We think our way ahead is quite bright with increasing opportunities. Asia is a unique and diversified and historical region. So Asia may not be the first to create the word arbitration, but we have a long history of dispute resolution. So that in my mind, Asian value is something that we shall preserve and develop for international ADR. And every one of us, all stakeholders and participants in arbitration community shall work together to take advantage of our potential in this emerging market. So in the end, if you have any questions, you can always reach us anytime. Thank you very much. And I'm looking forward to joining the discussions with all the distinguished speakers and audience. You are always welcome to visit us in Kuala Lumpur once our life is back to normal. Thank you, Professor Chi. The floor is yours. Thank you.
Thank you very much, Haiyan, for the kind introduction of AIAC and your own insights in the development of arbitration in Southeast Asian region. Thanks a lot for the talk. So last but not least, we have Ms. Susan Finder, distinguished scholar in residence of Peking University School of Transnational Law in Shenzhen, based in China. What I think I should mention is that Susan actually keeps a very important source of understanding Chinese law and Chinese judicial reforms that Supreme People's Court monitor. So Susan tonight will cover the latest developments in relation to dispute resolution, particularly the International Commercial Court. And herself is a member of the expert committee of China International Commercial Court. So Susan, the floor is yours.
Yeah, thank you very much. I'm just going to focus on some aspects of the China International Commercial Court, the CICC. Yeah, so as Manjiao said, I'm on the International Commercial Expert Committee, but nothing I have to say should be attributed to the Supreme People's Court or the CICC. And I'm not going to, certainly no time to comment on the many articles in English or Chinese, but just talk about what I understand the focus of the CICC work to be now, suggest some reasons, and then suggest some trends. So the CICC so far has accepted about 18 cases in the 3 years since it got started. So one important factor, it seems that when the CICC was approved, it was approved as a part-time court, because if you look at the profiles of the judges on the CICC, you can see that they all have at least one full-time responsibility. There's several people who have 2 full-time responsibilities. The Intellectual Property Court of the SPC was approved generally at the same time. It's a full-time court by contrast. Why one is full-time and one is part-time, I've not seen that discussion. So perhaps CICC, perhaps Supreme People's Court leadership thought IP needed full-time judges to deal with those issues. I'm not sure. So then the judges, so the CICC has a limited capacity to hear cases. What's that? Why am I telling you this? It means that the CICC needs to be strategic about what it does. And what I can see from some of the recent policy documents that the Supreme People's Court has issued, I mean, I won't give the titles here, but I could put them in the chat later. The Supreme People's Court is considering the best way forward, because there's language in I think the latest document about promote the construction of the CICC, 推进这个人民法院上诉法庭的建设, and 2 Chinese academics who are also experts are providing research to the SBC. So I think, so to me, they're moving parts from the point of view of the SBC. So based on my analysis of the types of cases the CICC has accepted and decided, and the CICC has published translations of their judgments and rulings so far, which is, they've made efforts in that area. So my understanding in the short to medium term, the CICC wants to be a model or a guide for China's lower courts and unifying what in China is called foreign related, substantive, and procedural law, because the arbitration law, the civil procedure law, other procedural and substantive law, it can't keep up with reality. There are a lot of gaps in Chinese law. So they're looking at what cases can kind of make law, but not in a formal sense. So in my view, they're more kind of domestically focused rather than looking at hearing large numbers of foreign related cases. Yes, so let's see, most of the cases have been referred from the lower courts. So what I can see is they look to see in what area, what are issues that frequently arise in practice and where existing law and judicial interpretations are unclear. And this role you can see from some of the Supreme People's Court policy documents. Yes, so in one of them it says, the role of the CICC in providing models and guidance shall be developed, and the role of cases in determining rules and guiding behavior. Let's see, 发挥国际上诉法庭示范引领作用和发挥好案例的规则确定和什么hold on, I think I missed a look. 作为指引作用. So the CICC has accepted and decided about 5 cases related to arbitration. So filling in the big gaps in Chinese arbitration law and their judicial interpretations. They've accepted 2 more, but haven't decided cases related to demand guarantees and standby letter of credit fraud disputes. So that's a big issue in China because of the BRI cases, and then they've issued a judgment on an issue related to product liability. So it's all cases where the existing law and judicial interpretations was unclear. Yeah, so additionally, they're looking to provide models and guidance. So I think that they seem to be also working with some of the lower courts, let's say, to work on promoting the one-stop diversified dispute resolution. I mean, ones that come to mind, the Beijing No. 4 Court and the Suzhou International Commercial Court. And I think we'll be seeing more from Haiyan as well. My guess is whatever guidance the CICC comes up with may also draw on best practices from the Standing Forum of International Commercial Courts, of which the SPC is a part. So what I can see from these local initiatives, some of the themes may include promoting mediation, So this is also in line with the Supreme People's Court's policy and mediation taking priority. And there's thinking, so there's discussions going on behind the scenes about China and so how to get China to ratify the Singapore Mediation Convention. What's called centralizing case acceptance. So addressing additional arbitration related issues. Possibly more rules concerning complex commercial disputes. So another area I think we may see the CICC or one of the local courts doing something is what I've written about as invisible BRI disputes, where there are cases heard in the Chinese courts between two Chinese companies involving projects overseas, particularly in the area of construction engineering. So there are issues, on how to expertise about foreign technical standards and improving the role of expert witnesses. So there are a lot of these technical issues where there's space for local, some of the local courts and eventually the CICC to build up China's international commercial legal infrastructure. So I wanted to say a few words about the expert committee. So so the members, they're Chinese members, so foreign members from Hong Kong, Taiwan, not sure about Macau. It's an institution different from a user committee in like US, Canada, UK, where they're required by law and focused on incorporating input from users in evolving court rules. So court rules in China are within the SPC's authority, and then local courts can issue them in practice as well, although the legality for these is not as clear. So it seems the CICC expert committee and other Chinese court expert committees appear to be established to enable courts to access expertise among the experts on a flexible basis. And it seems not intentionally not involving lawyers practicing in China. And so the link between the expert committee members and the subject matter competence is weaker than with user committees. And there have been 2 meetings so far of the entire CICC expert committee, and it seems more to be kind of making a larger statement rather than the more technically focused user committee. From those documents I've mentioned, it seems the SPC is still trying to figure out a proper role, at least for the expert committees, at least on the foreign side, because I don't believe the roles mentioned in the CICC regulations have turned out to fit with the SPC's actual needs and the very backgrounds of the experts. Because I was in touch with a number of the individual foreign experts, foreign members of the expert committee, and they hadn't been approached by the CICC to provide expertise in any form. So one of the roles would be mediation, but as was talked about earlier, so mediation outside of China is considered to be its own type of expertise. So, people like me, we wouldn't feel comfortable in mediating a dispute because we feel we don't have that type of expertise. yeah, so I guess for all these reasons, the time CICC judges have to devote to specific matters, the focus on progressing Chinese substantive and procedural law through CICC decisions and rulings, the use of lower courts to assist the CICC to evolve international commercial rules appropriate for China, and the flexible use of the expert committee in the short to medium term. I see the work of the CICC as more focused on developing Chinese foreign-related law, or the, I guess as the slogan was that 中受推进国内法治和涉外法治. Yeah, so I think this is where I see CICC going in the near future. So I look forward to your questions, and yeah, thank you for this opportunity.
Thank you very much, Susan, for your contribution to us with regard to the CICC, which is, I mean, to many is a new, but sometimes a little bit mysterious thing. Thank you very much. Yeah, well, yeah, while we are, I do have a question, I mean, a common question, but I think we already receiving questions. We have one question now. So I would like to raise this question to you before I raise to you the common question. So here is the question. The Asian Pacific region includes many smaller developing countries, especially the Pacific. I think the Pacific Island countries probably. In these countries, the government is often the primary economic actor and one of the parties that is likely to be involved in the cross-border dispute. Critically, the government is also likely and less powerful party in the dispute, with less access to legal advocacy resources than multinational companies. How, the question is, if at all, do the dispute resolution mechanisms that have been discussed, arbitral centers, international conventions, account for the presence of a state as a party and ensure that the weaker states with public interest concerns are protected to ensure a truly fair and equitable process and forum? Well, I think it's a very interesting and important topic. So if I may ask, I mean, the audience, Daniel Mandel, he or she does not mention to whom this question is raised, but I think any one of you, if you, our speakers, would like to try this question.
Well, I can give a try first, given that
Sure.
I have co-published a book in the area of Asia Pacific, covering Australia as well. But we do become aware that the Pacific includes not only Australia. So after we have published a book with Justice and Samuel Reyes, and their criticism didn't include New Zealand. But so I think the question is posed by this audience is not really referring to powerful states in the Pacific, but they're referring more to those developing nations in the Pacific. What I want to share here about the experiences with each KIC is that, they do handle disputes where the states from those smaller developing countries are one of the parties in the international commercial arbitration. So basically, state parties, they might be involved in two different types. One is commercial arbitration, the other is investment disputes. So if you're really involved in pure ICA, pure international commercial arbitration, I do think those leading arbitration institutions, experienced arbitration institutions like SIAC, or AIAC, they do have rich experiences in handling them in a just manner. Even for investment arbitration cases, HKIC has heard about, if my memory says well, we had lower than 5, not 5, but close to 5 in number about the investment arbitration cases with sovereign states. I think this is an upward slope, and then we are looking forward to seeing more in the investment treaty arbitration arena. And I'm sure that it's taken place in the other leading arbitration institutions as well. Yes, thanks.
Thank you, Weisha. Anyone else from our speakers would like to respond?
Well, maybe I can chip in.
Sure, please.
If you're talking about resources and concerns over whether a government or state can afford to engage in protracted warfare, I guess where the institutions come in would be their rules as well as your options. SIMC, which I mentioned just now, the Mediation Center, also has a collaboration with ICSID, as you know, the World Bank International Center for Settlement of Investment Disputes, investor-state disputes. So mediation is an option if you not want to go the full works, but basically mediation depends on both parties willing to clap, right? You can't have one hand clapping. But quite apart from that, what Weisha said is even if you go to arbitration before the commercial arbitration institutions, one thing that institutions are very much aware of is the growing concern over time delays and costs. So you are beginning to see quite a lot of policies as well as rules being geared towards faster arbitration, such as expedited procedure, and also controlling time and cost, which are a main concern of many of the leading arbitration institutions. The rest really depends to quite an extent on the arbitration tribunal managing the proceedings quite tightly. Now, while we speak about expedited arbitration, we know, of course, that this has been in use for a number of years to a great success by, say, SIAC and ICC has started using it, Hong Kong IAC. And now even UNCITRAL has been looking into it for a few years now on whether expedited procedure can also be used in the UNCITRAL rules, which are very popular for investor-state disputes. Thank you.
Thank you very much. So if there is no more responses from our speakers, Susan, you want to respond?
No, thanks.
Okay. So if there is no further responses to this question, I have this opportunity to raise a common question to all of you. As you have already observed, I believe that these recent years are very hectic in a sense, because we see that with the economic development despite the pandemic, we have a lot of changes. We have more fora like arbitration institutions, we have international commercial courts, we have mediation centers established, and in the same time we hear a lot about competition among different seats of dispute settlements, such as the seat of arbitration, is that Singapore, Hong Kong, Beijing, Tokyo, or anywhere, Malaysia. It's also the competition among the different alternatives. While people are saying that arbitration is good, but someone would prefer court or a combined or hybrid, in Weisha's words, the hybrid ways to solve these disputes. So despite all these kind of complexities, so the question is, in your vision, what would you think about the landscape of international dispute settlement in the Asian Pacific in the next decade? So if I may invite our speakers to just briefly respond, and probably in the order of presentations that make things easier. So yeah, Weisha, would you please?
Thank you very much, Manja. This is a fascinating question. I think you've touched upon many of the aspects I would have loved to say in my rather limited time of presentation in the beginning. It's a competition of seats, a competition of fora, a competition of means. So there are three different layers of competitions that you have envisaged, which I agree entirely. So I think this is a race to the top rather than race to the bottom in the Asia Pacific, even though we think that, some of the layers of the competition may have the likelihoods of running into a race to the bottom, as I've argued in my international commercial piece that will be forthcoming in the Chicago Journal of International. But in terms of the Asia Pacific, as we have seen, especially like, and after we have published the book and was published in 2018, you will see that in Japan, in addition to JCAA, they have established JIDRC and JIMC. So you will see that this is a very healthy and lively culture that people in different jurisdictions of Asia Pacific, they would care about the diversity. They would like to care more about the options, in the words of Lan Sun. So there are more viable options that would be alluded to the clients in their eyes. From academic perspective, I think this is more sort of, a one-stop shop in various jurisdictions, as I've seen in China, in Japan, and then in Singapore. And then I'm sure that other jurisdictions, like, some of the questions I've already answered in the chat box, like Taiwan, they are also making some, not that aggressive, but some modest sort of, amendment to their arbitration legislation to take advantage of those brings to the top. So I would envisage that in the next decade, arbitration institutions and international commercial courts will become part of soft power of economic package or investment package in leading jurisdictions. And then from my social science research, I think there is a positive causal link between International Financial Center and International Dispute Resolution Center. And then I think this causal link would be more robust if we have more data. So thank you very much.
Thank you, Weisha, for the insights. So now, Yuko, would you please?
Thank you very much. I think I mostly concur with what Weisha has just said. I think we do have a large competition in the Asian region in terms of selecting the venue for dispute resolution. But I think it's also a race to the top. So we are providing better service and better facilities. Also, the Japanese government is promoting Japan as a venue for arbitration and mediation. And what we are now trying to do is provide the advantages we have in Japan as a civil law jurisdiction, so different from Singapore and Hong Kong. Because we have a different legal system, and that may be an advantage we can provide to litigants coming from civil law jurisdictions, for example. And we are also trying to provide less expensive service for arbitration. And we are getting a larger pool of potential arbitrators that can be selected by the parties. So I think by improving our service, we are trying to compete with other advanced jurisdictions, and that will lead to positive competition in the future. And we do hope to keep up with other jurisdictions. Thank you very much.
Thank you, Yuko. That's very important to observe this kind of upcoming positive competition. So Chanlan, would you please?
Sure, thank you. Well, to answer your first point very briefly about what kind of disputes mechanisms will be used, I think you and I probably both agree that we'll see a lot more options being explored by parties, not just litigation, not just arbitration, but some kind of hybrid forms with more recognition and familiarity with mediation. You might see it being considered as an option as well. And you'll certainly see some hybrid forms coming up. Now, as to the growth of Asia Pacific itself, many corporate users and their legal advisors are now comfortable having their disputes determined in Asia Pacific. And we can see a growing volume of cases being arbitrated in Asia. I think there will be a slight twist going forward because of COVID-19. Before COVID-19, a lot of emphasis was placed on physical hearing facilities and the infrastructure of the seat of arbitration. COVID-19 has forced us to go online. I believe that physical hearings will resume when we can travel, and I hope it does, because I think we are all tired of being stuck at home. But there will be more virtual hearings, and I think virtual hearings will continue to be an option now that parties have found out that they can work. And what this means is that parties will no longer consider physical facilities to be the primary concern. They may not. But choosing a legal seat is still important, because this brings in the whole legal ecosystem, such as the lex arbitri and the supervisory court of the arbitration. Hence, popular seats in Asia Pacific will remain those whose legal systems give comfort to parties. I think that would be my observation. Thank you.
Thank you. That's very, very helpful. I mean, it discusses the potential, I would say, the picture in front of us, especially after the pandemic. So next, Haiyan, would you briefly respond? You have to unmute.
Yes, thank you. Yes, yeah, thank you. Actually, I have about the competitions in the Asia Pacific in the arbitration community. There's two, I would say, there's two reasons coming to my mind. And the first one would be the increasing awareness from the Asia Pacific, especially Asia, like continent Asia, about the ADR. So as you can see, like, I think before, I still remember, like, back to the conferences that we had a couple of years ago, that you mentioned that we have treaty taker and treaty maker countries. So I think the same applies to ADR, because before, I would say many Asian countries would apply the Western law, especially the UK law, as their applicable law in arbitration. And nowadays, you can see some Eastern value and has been demonstrated in the ADR. The good example, of course, is the Singapore Convention on Mediation. Actually, yeah. So, and another point is that I would say the educations. My experience is that before I was in the undergraduate students in China, that we are not really familiar with, for example, investment arbitration. But now investment arbitration is something like a hot topic in China. I mean, the students also attend different competitions. And another factors, I would say, is the economy. So as I said in my presentation, that we have the increase economy, so which will also result back the awareness of the ADR. So about the future, I don't know, but I think I will witness, I think when I was still in this area. So I think it's going to be exciting, especially when the ADR comes into play, when nowadays with the 5G and all the technology come in. So I think it's going to be very exciting. Thank you.
Thank you very much. So I note that our time will be expiring very shortly. So Susan, would you want to have a very quick response? Thank you.
I want to talk about something slightly different. What I think is going to be worked out in the next 10 years in Asia is figuring out, I guess, stepping back to China, the state-owned enterprises, are extremely important in China, but also in many other jurisdictions in Asia. And I foresee work on how to get state-owned enterprises to be able to mediate their disputes, because, in my discussions in China and abroad, there are a lot of factors. Also, Lucy Reed has done research on this. For a variety of reasons, SOEs tend to want to have a judgment or arbitration award, so that senior management of the SOE doesn't get into trouble. So I think we're going to see more work. On the Chinese side, it's going to take a lot of detailed work to make it possible for this to happen. But I think this is an area where we'll see further work in the future.
Thank you.
But yeah.
Thank you. Thank you very much, Susan. For the sake of time, I'm sorry, this is my fault, delayed by the technical problem. So I would, in 1 minute, I would very quickly close this webinar. First of all, a huge thank you to all our distinguished speakers. Thank you for spending tonight with us, and we benefit a lot. And second, of course, I would like to convey our thanks to all our audiences. We don't have a lot of audience tonight on this webinar, but I know there were a lot of followers on YouTube or ASO website. They will watch our video clips. So I invite all the audience to stay with us for the future webinars. This is a series. So again, thank you very much, and hope you enjoy the rest of the day. Thank you and bye-bye.